Recording. Yeah. Hello everyone, this is Atin Handuja, founder and CEO of Legal Foxes. I hope you all are well. Today we have our workshop on the topic how to draft a moot memorial. And today we have advocate Jay Govind here. He is practicing advocate at Kerala High Court, and he had won many moot court competition and get many best memorial awards. Welcome to the session, sir.
Thank you, Atin.
One thing I would like to know. One thing I would like to tell you that if you have any questions, you can write in chat box, and questions will be taken in last 10 to 15 minutes. And over to you, sir. Now you can start your session.
Thank you, Atin. So, good evening, everyone. As Atin already introduced me, I am Jay Govind, and I am currently practicing in High Court of Kerala. And this will be your workshop session on how to draft a moot memorial. So, first of all, Atin, can I have the PPT on?
Yes, sir. Just a second. Can you see the PPT?
Yes, I can. Thank you, Atin. The next slide. So, first of all, I'm going to assume that most of you have an idea that what a moot court is, and obviously that's why you all are here. And so, first of all, I won't be going through what all are the parts of a moot memorial, because most of you are already aware, or most of you are already working with a memorial that your seniors did, or you just Googled it, or you found it on the internet. So you already have a model. So I won't go on to explain it. I'll just go on with it later. But I'll include, my class will be basically on what are the most important parts, and I'll guide you through my experience on how you can start working on a memorial from what are the main important parts, what all should you be doing once you have the problem in your hand. So just to a rough sketch, I'll tell you where to start. Then I'll guide you through three important parts of drafting a moot court memorial. The first one being how can issues be framed. Second, how to do research. And third, drafting the argument. And then I'll just run through the contents of a memorial. And after that, I'll share some points that I felt didn't fall with all this, but are nevertheless very important. So moving on to the first slide, where to start. So by this time, you are in a moot court team and you have the memorial in your hand, and you are just wondering, what should I do first? Should I go on to the issues? Where do I research? Or what should I read? So what I suggest is, first you have to read thoroughly the moot proposition. And when you go through that, you will get a fair idea on what it is about, or which part of the law it is touching. And that is very important, that you have to identify this. You basically just the proposition will itself reveal. When you read through it a couple of times, you will get an idea. So the first thing is you have to read through it. And the next thing you have to do is you have to just randomly Google it. Like, you have to create a peripheral idea, meaning you have to have a layman understanding of what the problem is. Why is it relevant? Is it based on any recent development in the law, or is it based on any recent case laws that is being discussed? So most of the time, the moots are usually based on some point of public importance. So some cases that have recently come up there, some cases which have been of controversy. So you need to have a peripheral idea. You don't need to go through anything. You don't need to start reading judgments, but you have to get an idea of what's happening, what is the subject about, what is the situation. If it's in India, what is the situation in India? Are there any important case laws that happen? Just have an idea. Okay, just grab an idea of the timeline, and that's it. So you now have read the problem, and you have read the real life peripheral idea. So you have an idea that this belongs to this portion of law, if it's constitution, if it's relating to fundamental rights, or is it just some other law, is it company law. So you get a peripheral idea, and you that is the base where you start from, because you can't just randomly go to the issue at first. You have to have a peripheral approach to. So this is why this creating this peripheral idea is very important. And once you're done with that, you have to go back to the rules and regulations that the moot proposition has put forward. So the host, the party conducting the moot court, will already have sent you the link to the rules and regulations, and you need to read through it, because you have to plan well on how you're going to work on this moot. You need to have an idea on how big the memorial should be, meaning how many pages it should be. So it will give you a length, how much time you will have to invest in this, and how much time you have left, and what all things they are expecting from you in your memorial, and also at the moot court when you start participating. So this is important, because whatever you're going to create from now on, it will be solely based on the rules and regulations, and you have to conform with it, and you have to plan accordingly. Whatever it is, you have to make a timeline on when I'll finish my first draft, when I'll finish my second draft, when I'll be able to finish my third draft. So that will give you a pathway to work on. So you are in a big map, you are streamlining yourself to a particular idea, and that is very important. Now you have a peripheral idea, you understand the moot court proposition, and you have an idea of the rules and regulation, and now it's the time you move on to the issues. Can I have the next slide, please? Okay, the framing of issues. So you already have a team of 3 people, and you're starting to work on framing the issue. So I always suggest that you work all 3 members of the moot court team should work jointly in framing the issues. But after that, you working on it, that is according to you. You can either choose to work separately or independently. That will solely depend on you. But framing the issues, I think the whole team must coordinate, and they must work on framing the issues. Now let me go on to what the code of civil procedure talks about issues. So order 14, rule 1 clause 1, it says issues arise when a material proposition of fact or law is affirmed by one party and denied by the other. So we are not going to touch about material proposition of fact, because most of the moot court competitions, it's not about facts. Issues of facts are very rare. It's mostly on issue of law, because it's mostly in the appellate court or in the high court or in the Supreme Court or above in the International Court of Justice. So it's mostly the material proposition of law. So what is important is there is a material proposition, meaning a proposition that through which the parties claim a right. So there is a no. So there is a particular proposition. There's a person is claiming that I have a particular right, and the other party is denying that. So we have a proposition of law, and it is one party is saying that I have that right, or I have that defense, and the other party is saying that is not correct and you are not correct. So this is what an issue is, and this through this this can be stepwise done. If you identify 3 steps are, first you need to identify the party. So most of the moot court propositions, you have there might be 2 or more parties, or there might be many other parties who will be going against each other. So your first problem is to identify who the petitioners are and who the respondents are. And once you are ascertaining that, then you have to identify all the rights, duties, immunities, or defenses that are specific to this problem, and what all these petitioners and respondents are talking about. Because this time you don't have to go through the rights and duties of the petitioner in general, but it should be specific to the problem. You'll only have to go through the problem, and you'll have to identify those rights or duties or defenses or immunities that the petitioners or the defendants respondents are claiming that they have. Now, moving, once you are identified these rights that are specific to the problem, the third question is to the third step is to identify the point of conflict. So the thing about issue is it should be affirmed by one party and it should be denied by the other. So that is where the main point lies. You have to identify the point of conflicts. Only if there is a conflict between both those parties and this conflict is relevant in law, issues can arise from those. For instance, if a public interest litigation is filed by an NGO, it is a public matter and it touches the rights of the public. And at that point, you cannot raise an issue about locus standi, because it won't be a valid point of conflict in law, because a public interest litigation can be filed by any person when it is touching the interest of the public. So that won't be relevant. What is important is you have to identify the point of conflict in these rights or duties from between these two parties that is relevant in law. And when you identify all these points, and that is when you have the issues. So it is not necessary that you are able to identify all the issues at the first instance itself, because you at this point you do not have a correct understanding of what all are the law involved, because you didn't go deep into it. So you just have the peripheral idea, and you just identified the parties, you just identified what are the rights they are claiming, and so you may not be always able to identify all the rights. So but some of them you'll be able to identify, and we'll work from that. And as you move on with your memorial, you develop it and you will get better and you will get more issues. That is how you work. It is not a fixed like step by step that you frame the issues, then only you can move on to the next one. Because once you identify the issues, you you cannot identify the issues always at the first point itself. You need to work on it, and once you're done, you work on the next part. And framing the issues may not always be a problem, because most of the time the problem moot proposition itself will have framing the issues framed for you, so that there is not much confusion. But most sometimes they do not frame the issue and they leave it to your discretion to frame all those issues. And it is at that point all these points become relevant. And in relation to framing of sub issues, that also is developed once you start working on it. Only when you start researching on it that you will be able to identify, oh, okay, there is a sub issue that is coming up, I should also include that. For instance, you are a petitioner who is challenging the constitutionality of an act, and it is a with respect to Article 14, you're challenging the constitutionality of an act, and you are the petitioner and you are putting an argument that this is unconstitutional because it is arbitrary or because it does not satisfy the reasonable classification clause. You say that, and the next question comes is, so if only a particular section of this act is violating Article 14. So the next, as you move on with your research, you learn that, so what will happen to this act if only one section is unconstitutional? Does the whole act go down, or is it just that particular section? And then you research and you learn about the issue, the doctrine of severability. So it is as you research that you will be able to come up with more and more sub issues. So just go with the main issue. Sub issues will come when you once start researching. So that won't be a problem. And so now on, we'll move on to the next issue. How do we research? So you have the issues in hand, and by this time you should have decided all the issues among your teammates itself. So one person will be working on a particular issue and the others will be working on other issues. And now it's time where you have to go on to research. So how do you do that? So once the first step is, once you have the issue in hand, you have the first issue in your hand, the first thing you have to do is identify the primary authority that deals with the issue. For instance, it's like take a constitutionality example. You are challenging the constitutionality with respect to Article 14. So the primary authority is Article 14. So that is what you identify the specific section or the specific act or the specific article in a particular act or in a particular piece of legislation that your issue primarily deals with, and that is from where you will diverse out. So you have to have a complete understanding of what what is the base of that issue, in which portion of which part of law that issue touches, and from there you will have to start working on. So first thing you have to do is you identified a particular section, then you will have to go through a well-known author of the book. You will have to go through a good question. You will have to go through a good book or a who is reputed in that part. And once you have that book in your hand, you just have to go through that article with that specific part, and you read through it. Basically, if it's a good book, if it's a good commentary, then it will have a specific section that will be dealing with your problem, that's for sure. And once you read and study that part, you'll realize that there are lots of other sources that are cited in that book itself. So there will be many cases, there will be many articles or many academic matters that will be dealt with in that part. So that is the next step, that is branching out. So from by studying the primary authority, you will get an idea of what all sources you can get the research from. Now this is very diverse thing, because you're reading, you find that a particular case law is dealing with this section, and you read that case law, and in that case law itself you'll find an enormous number of case laws that has dealt with this legal principle. So even when you go to that, you will find many cases that deal. So that is what branching out is about. You start from a specific primary authority, you start researching on that, and that primary authority will give you the idea on where you get all your extra work from, where you can do research on. So you branch out, you're finding that these all case laws are there, and you are going very wide. And that is where step 3 comes in. You have to analyze and screen out the relevant sources, because once you start branching out, you may find yourself cutting off from the moving away from the topic, and you're wandering off. That is quite natural, but you need to identify where to stop. So just like I said, if a case law is leading you to another case law, and it is leading to you to another case law, that third case law that you identified may not always be relevant. The judge might be in that case law dealing with another point of law that is not being discussed in your moot court problem. So we don't need that. We only need what is relevant to us. And that is why you need to analyze and screen out the relevant sources, because then only you will be able to identify what all are different. And another thing is, this branching out is very important, not just for your memorial, but also for your presentation, your oral rounds, because the judges who will come for your uh, who will come to judge you, so they will all have their own field of expertise. So once you start arguing on a specific problem, and they find that it is something, the judge finds that it is something that they have great interest in, or they are finding out that, okay, I am an expert in this, might as well pose the questions to him about that issue. And at that time, when he poses you a question that is not directly related to the moot court problem, but it is something else, but nevertheless it becomes relevant, you will have to answer him that, and you will have to come back to your main point. And for that purpose, you need this branching out is very important. You need to have a basic understanding of what all is happening around. You need to know that okay, this is that how you will have to explain to the him to the judge why that case law or why that proposition may not be relevant here. This is very important because you know it is not just about learning about the specific problem in hand. You'll need to at the same time give give out the impression that yes I have done research on this, but what we have to focus is on the primary problem in we have in hand. And branching out is another way important because there might be case laws that feel that seems to be relevant here, that seems to be relevant in your memorial, and you identify that it is not relevant, so you leave it. And but the other party, your opposite party, okay, I'll answer that in the end, that question. Okay, analyzing and screening out now. So you need to tell the other person when your opposite party comes up with a particular case law, you will need to explain to the judge why is it that not relevant, and you cannot expect what all the other party will be coming up with. So you will have to have an idea of what all he might bring. We cannot say in for sure what all will be important. So you need to have an idea of what all might possibly come up, and for that you will have to identify, you have to branch out, and you will have to have a thorough understanding of all the legal principles that the primary authority sets out or the case law sets out, and you will have to identify why that case is important, why this one is important, and why. And sometimes you will have to argue on why that reasoning that the judge has applied in that case is not relevant to this case law, why that facts of why sorry why the facts of that case is not relevant here. So in that instance, branching out is very important. And again, going back to analyzing and screening out relevant source, this has another aspect too, because uh, you might find lots of academic contents or case law that might seem relevant to you, but what is relevant is it should be legally binding. So you need to understand that all these parts, all these cases that you're suggesting, or all the academic literature that you're putting in are relevant. So you need to analyze what all are important, what all are to be taken into concept. But analyzing it also gives you an important idea on what all is left out and why it should be left out. And screening out means screening out as in in your memorial you need not include all that is included in this branching out. Usually you will have a limited number of pages, so there will be a limitation on how many pages that you can go into, you can write in the memorial. So there is a limitation. So what is relevant is you will have to screen out what all are relevant and only include that in the memorial. When the oral round comes up, if the other party brings anything up that is not in your memorial, you can always argue that because you already branched out, you already have done your research, but you need to include what all are relevant. So that is a very important talent that you have to develop over time, and not just as a mooter but also as a lawyer. You need to screen out what is important and what is not. And when you draft it, it's very important because usually when a person have when the judges who correct a memorial, they might have around 30 32. If there are 16 teams, they'll obviously have 32 memorials, and they'll only have a couple of days, 1 day 2 day or 3 days, to correct all these memorials. And the thing is, they won't be going reading into every single passage or every single case law. They won't go research on every single case law or every site you have added. So it is important that you keep the arguments crisp, and for that you need to understand what all are important. Only then can you analyze, okay, this is important. This I need to include in the memorial because it is very important. Or you can say that, okay, this is not important. I do not need this in the argument. But if it comes up in the oral rounds, I can argue that. That is why screening out the relevant sources is an important. Now, this researching and drafting the argument, it is not a step by step. It does not go like you complete your research first and then you move on to your argument. That is not how it works. Once you have the issue sorted out, this research work and drafting the argument goes hand in hand, because it works simultaneously. You will have to keep on editing. You then move on with your research and you find something else, or you find that what you wrote in the first instance was not correct, or there might be some other case law which is more important. So this, both of this drafting and researching have to go hand in hand. Then only you will be able to chim out the best possible argument. And coming to drafting the argument, so just like I said, all your arguments have to be very crisp, meaning you only have a, you might have a large number of case laws. You've done your research, you're continuing with your research, and you're finding that there are large number of case laws that are dealing with this issue or the problem in hand. There is a lot of academic discussions going on. So you will have to be very crisp. You need to identify this is important. And you have to structure that in a very well manner, so that when the person who's correcting your memorial is reading through it, he'll understand, okay, he has done his research and he has identified all the relevant parts and only what that is relevant, and he has been successfully able to articulate that into your argument. to to do this, you need to structure your argument. So now I'll move on to how you will structure an argument. How do you draft the argument? So what I suggest is, what I have learned is, first thing you have to do is, you have all the facts in your hand, but you're going to deal with a specific issue. So you bring out the fact that is specific to the issue, specific to the argument. So you are saying that this for instance, in a case, you are saying that your case is maintainable. The maintainability is an issue that you have found, and your argument is that your case is maintainable. So you need to point out the fact why that particular particular petition is maintainable in the facts. For instance, it might be touching a fundamental right, and since it's touching a fundamental right, it's maintainable only in the high. It can be maintained in the High Court or in the Supreme Court. So you are stating that it is that way, so that you're stating the fact this matter is touching the fundamental right. That is the fact that you bring out. And the next thing you have to do is, you have to state the law in this. Now, stating the law, it is when by the time you have done your research, you would have identified your primary authority. That is usually the legislation. So the legislation will clearly set out what the law is. But that question, what the legislation sets out, cannot give you a comprehensive idea, or cannot answer the specific issue that you have posted. So once you have stated the legislation, the next thing you have to do is, there is legislation is always ambiguous, and that is where you have the moot problem in your hand. That ambiguity you have to fill using case laws, and that is where sometimes the legislations might not just be enough. You will have to include the case laws in it. And when you include the case laws, there also you will have to include what you have to identify the hierarchy, because this case, the moot problem might be posted before a different bench. It might be before an international forum. It might be before the Supreme Court or the High Court or any other forum. So in that instance, you have to have a clear structure of how you arrange the case laws. You will have to obviously start with the highest authority. You're not going to put case laws in randomly. You will have to follow that authority. So if it's before the Supreme Court, first you pose those cases that are set out by those case laws that are set out by the Supreme Court. So once you have done that, you might after citing the Supreme Court cases, you might move on to the High Court cases, but that might not always be relevant if it's before a higher authority. But when you are citing that, you must always remember that that case law is relevant. So structuring our argument, we have first dealt with the facts. We have brought out the specific fact, it's specific to the argument. Then you are stating the law. We have dealt with which legislation we are dealing with. And the next thing, we have dealt with the case laws. And in the case laws, we have identified, we have formed the hierarchy. It's a highest level of hierarchy first, then the second. So that has to be followed. However, even the case laws that you have brought out might not be specific or answer the specific issue that you have raised. So once you are dealt with all the case laws, if it's most probably it's about Indian case laws, but then situation might be in India, then you might add foreign case laws for to use the reasoning they have included. So many a times again, we are following a hierarchy. We are posing the Indian cases, then we move on to foreign cases if at all it is necessary. So always keep in mind what I said prior. You need to screen out only the important part. So sometimes you might not need to state what all are the laws that the High Court has set out or what all the Supreme Court has set out. There might be instances where none of the Supreme Court cases or High Court cases and deals with this issue. So we'll have to solely depend on foreign case laws. You may face such issues. So that
I'm sorry to interrupt, sir.
yes.
After 2 minutes, this link will expire, and you have to click another link at 5:35.
Okay.
Automatically, this link will expire.
Okay.
Yes, sir. Please continue.
Okay, so from we have an idea of the case laws, we are structuring the case laws, Indian case laws, then foreign case laws, and here what is important is you will have to uh, only refine them. You have to only add what is relevant because you have to be close. And when these case laws also does not answer your question, that is when you will have to move on to the academic literature. So what is important is here is you might move on to parliamentary debates, you might go on to research papers, you might go on to what all like luminaries in the field of law has suggested, or you might deal with specific uh, reports or any other issues that might sway things to your favor. So that is with regard to academic literature. Again, it is not compulsory that you need to include the academic literature. Only if the legislation fails, only if the case laws that you have cited, you feel that it does not answer your issue, then only you will have to include the academic literature. So it's all about finding what's relevant and screening out only those what is important. And now we have the facts, we have stated the law. The next comes the application of the law to the specific fact. I think we'll
It's
be
about
running
to
out.
end. It's about to end. So you can